What's up, folks? Listen, co-consuls. I should have actually thought that I had the tonight's live stream pre-scheduled. Apparently not. So I apologize. In any event, let me share my screen. A lot has been going on today. Okay, just based off the titles, a lot has been going on. I could not watch today's hearing, unfortunately, because I was working. I was working and I'm under a lot of stress. But let's get into it. I have so much to pick from. You guys know I'm a little indecisive. I have a lot to pick from. Like, where do we start? Where do we start? I guess let's start off with a squabble.
They clearly
Okay, so tomorrow's what, Friday? Yeah, tomorrow I will take the time to actually watch the hearing from top to bottom, and then obviously I'll have a recap on Thursday.
would have
No, not Thursday. Today's Thursday. On Monday.
that clearly would have adversely affected.
Okay, let's see what they're fighting about.
They clearly would have that clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If
I need context. I'm a context type of person. I need to know what was said before. Before your Nettie. I don't know. They're talking about Bev. Let's
if I
get into
allow,
this.
and I'd be very surprised if I did mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now and then? I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh, you just said
I
it's
can-
late. Hold on, you just said it's later in the
I
argument.
know,
Hold
but
on,
I said
let's get back. I'm sorry. I need to understand why they're fighting. What are they fighting about?
Brought up that he'd be able to get into.
okay. So first of all, and this is later in my argument, we're not asking.
So no, could you answer that now and then? I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh,
If-
you just
if
said
I
it's
can-
late. Hold on, you just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
Listen, this is not a fun spot to be in. I'm stressed out today. I had a real fight today. Okay. Today was a real back and forth argument. I'm so stressed out.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial.
Okay.
We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an
All right. I'm gonna take a moment to think about that. Why does the defense want this in? What are their interests?
investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered, nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my clients, to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that.
So I take it Brennan then would want to get into the experts being actually retained by defense and defense lying about it.
The ARCA witnesses were just attention seekers.
What?
Looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball. when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government
Is that it?
got,
Are they done? Are they done
Mr.
fighting?
Brennan engages in a ton of speculation about what happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA. And they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that
Is that
ARCA
it, Wizbev?
should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with. And all of a sudden it was revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same
Come
time,
on, Brennan.
and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay. Any follow-up?
Yes. Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government,
I'm
and the jury's
parenting.
for a slight is going to
Hold on.
respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury is entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now,
I'm
I
parenting
didn't
out
know
here.
that
Give me a
Attorney
second.
Genetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence or we were hiding from the truth. We weren't invited. We didn't know. Now, I hear now that Mr. Yanetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023, describing his client's best memories of events.
They're doing a whole lot of writing
about the case. So there clearly is a
or
relationship
documenting.
that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence information you have. As you've seen from the ARCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examine a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses.
Okay, Brandon's done. Let me see what they're saying here. Okay, let us move on. I think what I want to move on to, okay, this is what we really want to talk about. Okay,
And for the Commonwealth.
Morning, Mr.
get in
Brennan.
here.
Good morning, Your Honor. Alan Jackson from the street.
Good
Again,
morning.
I did not watch this, but I do have a position from last night. I think probably even from the night before.
Mr. Jackson.
Good morning, Your Honor. Elizabeth Little.
Yeah, from the night before, because today's what, Thursday? Must have been from Tuesday.
also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Leslie on behalf of Ms. Reed.
My
Good morning,
favorite.
Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning, but what I want to start with, I was just handed a couple of things too that I'm going to need some time to read.
Okay.
What I'd like to start with is paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th.
Okay.
Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
Okay. I suppose I'm gonna let Jackson go first, but we had a brief. Sorry, folks. I don't know what you guys heard, but I had to adjust myself, and that disconnected my mic. In any event, let me first hear what Jackson had to say. I have some thoughts about this.
The court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else.
Let's see. What's Brooklyn saying? 2 links? I don't know why I would have 2 links. Let me take a look. Let me go to StreamYard. No, I only have a What's the date? I don't actually know the date. I suppose there's a link that was for the 17th, but I thought I changed that because on the 17th, on the 17th, I believe I had completely changed on the 17th. Oh, Jason's here. I don't know why. I don't know why this is live. Let me just change. I'm chaotic, you guys. That's what I thought, but why is it showing up as the 17th on my end? Because when I logged on, I was gonna shift the other live to a different date, but it said that it was scheduled for the 17th. Anyways, it's chaotic. I'm moving that to the 24th. Okay, I moved that to the 24th. Okay, well, thank you, Jason. All right, so let's. I'm gonna close out. Thanks for bringing that to my attention, Brooklyn. Yeah, I'm sorry. I don't know why that was the case, but something happened. In any event, let us get back into Jackson. I have to go back a little bit because my daughter was out here and she's supposed to be in bed. Okay, it's 8:48. She needs to be fast asleep, but she's not. Okay, let's. I just want to hear what he has to say from the beginning because I do have. We touched a little bit on this on Tuesday.
Likely going to happen, so I need to hear argument on why I should do this.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
Okay, I'm trying to understand Jackson here because I was thinking about, like, I don't have actual work to do. I was thinking about this application. I was thinking about this earlier today. I still don't quite understand Jackson's position. What I mean by that is once jeopardy attaches, right? Um, they can move for a mistrial. So why is that a bad thing from the defendant's perspective? That's what I don't quite understand his reasoning.
All three indictments.
But again, there must be, I'm trying to figure out what his interests are. There must be something else that he's not communicating there. There must be a different factor, a different reason that he's not actually but at this point, I really don't trust Jackson. Okay, big shout out to Alessi. That's my guy. Jackson, he's his credibility is shot in my eyes. Okay, I'm not the judge presiding over this case. Definitely, I don't know that I'll ever be a judge, but his credibility is shot. I don't trust anything that's coming out of this man's mouth.
very clearly is a murder case, ultimately, along with
All three indictments, correct? You're
I understand
defending
that,
all three.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why.
Okay, so unless, because again, I'm just thinking about this. I'm thinking about this. Unless Jackson is hoping that the First Circuit actually dismisses the first 2 counts, so he doesn't actually have to proceed or touch on them at all. I think that's what he's probably hoping for. Other than that, I don't understand what would be that bad when it comes to moving for a mistrial. So I think that indirectly he's pretty much hoping that the circuit court or the First Circuit rules in his favor.
Suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice. And we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance.
Don't they have other cases to try in this courtroom or in this district?
Submit.
All right, does the Commonwealth want to be heard on this?
Here he goes. Man got a haircut or something.
Your Honor, the Commonwealth is relying on advice of appellate counsel.
Okay.
I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is
Why is it taking
that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible.
Okay.
There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in the federal court.
I would be surprised if you did not watch this, Brooklyn. Yeah, this was today's hearing. I did not watch it. I was working. I was preparing for my hearing, and then my hearing came and went, and I'm still stressed out. So, yeah,
We don't directly communicate with them.
that's why I'm doing the short clips, because I did not have time to watch the entirety of the hearing.
Control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I
Okay.
understand the trial strategy for different charges is somewhat different. But most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly,
Okay.
and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All right.
Bev said no, 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 no. I am not persuaded. I'll explain in a moment. Let's see where Bev is going, but this has to do with the what's his name again? With Alan Jackson's violation and skirting of the rules. That's
Court will
ultimately
act
where
more
it goes.
quickly, and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All right. We have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start
Geez,
in
the
panel.
last 20 minutes. Well, I'm going to have to find those last 20 minutes. Okay. Yeah, definitely I'll do that before. I'll do that before I end the live. And again, I'm stopping around 9:30. I'm sleep deprived, but I'm stopping around 9:30. Okay, so I guess it was very fiery.
On April 1st. It will likely take a while.
Okay.
If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches.
Okay.
And we'll take it from there, but we will start April.
Let's see. Yeah, that is true. Jeopardy does attach when the jury is sworn in, when it's a jury trial. And I believe when it's a bench trial is when the first witness is sworn in.
First with impanelment.
Thank you, Your Honor.
Okay. All right. So let's go to the
Okay,
next.
so I thought my reasoning was different. I mean, the whole, concerns about the juries, that does make sense because, I mean, it's only happened once, though. It's only happened once where the jury commissioner had a problem with jurors that were subpoenaed, but the judge actually ended up, if I remember correctly, let me go back. This was, I don't know, 3 years ago, maybe, but no, it has to be 3 years ago. Um, so under those circumstances, I guess Bev is really just, covering her behind here. Uh, because usually trials, when I'm around, trials go. But there was a specific instance in one of the jurisdictions, when I was a public defender, where I had in advance notified the judge that my client would be out of the state because she had to attend um, a funeral, right? But he pretty much still went ahead, and he was not going to budge. Okay, so he decided to um, get everybody in, and the commissioner had concerns, and they actually started investigating the judge. They asked me questions. I'm like, I don't want to be involved in this stuff. Like, don't involve me. Don't involve me in this stuff. Handle this stuff on your own. But I understand her concerns. I actually thought that Bev's decision was based on her allowing Jackson to proceed with this case, because, in all honesty, she had all the Jackson clearly violated the rules. Okay, so under those circumstances, she certainly could have removed Jackson. But my theory is that she did not remove Jackson because she actually wants this trial to go. Because had she removed him, there's no way this trial was going to go. Because Karen Reed would have to, even if there are other attorneys that could have proceeded, she could have pretty much made the argument that she wants a new attorney. She wants to hire somebody else, and that would delay the trial out for, I don't know, another year, 2 years, 3 years, who knows.
Motion, and then we'll go back to doing them somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? Because I don't know where I put it.
Yes.
I have it here somewhere. I'll find it. So we did hear from people this morning. I know you all have, I have it. I have it, Jim. I think Mr. McDermott gave you a copy of
After this, we're going to go to the
I
last
guess
20 minutes
what
because
local
co-counsel
merchants
has
have requested.
instructed us to do so.
We received it.
Okay. All right. So I'll hear the Commonwealth on your buffer zone motion.
Is it me, or did he get a new haircut?
Your Honor, the Commonwealth's primary concern is the sanctity of the jury and the jury process. We are concerned, based on past reports and information, that noise, interruption, and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but other types of noise that
What,
could be
chanting?
influential, intimidating, concerning. And so we've proposed what I think is reasonable and minimal recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence to the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases at other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that they have expressed to the court. And I do think that the court should be sensitive to the community's concerns. But importantly, that closeness and that amount of volume and influence on the jury, I think, can affect the sanctity of the jury.
Okay.
I don't think it is a strong imposition to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
All right. Is that it?
All right. There's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce.
Okay, hold on. Oh, actually, did we? Okay, hold on. Excuse me. Now I quickly just have to take a quick peruse out here. Excuse me. Okay, I'm just trying to see. Okay, let's go to. I actually wanted to. There's one more thing. We might be here a little longer. Okay. Tell me if this is it, Brooklyn. Okay, so this video that is titled "Karen Reed gives State Attorney dirty looks." Is this what happens in the last 20 minutes? Because if that's what happens, then I suppose, then there's no point. We could just go to the last 20 minutes. Okay, so Brooklyn thinks that Brennan looks defeated. Maybe. I don't know. I mean, Proctor being terminated, that kind of changes the landscape a little bit, but as I said, I did not see the prosecution dropping the charges simply because he was terminated. But is this the portion that you want? Actually, let me just go to the live stream. Let's go to the live. Now I have to find it. I cannot see. What, did they not live stream the video or the hearing? I don't know. Let's see, Court TV. Uh-oh. I don't know why it's doing that. So Court TV. What, they're back in court? No, that's the 25th. I was about to say they're back in court tomorrow. All right, let's see. Let us see. Where is she? Dang, they were in court for 6 hours, maybe 5. Let's go to the last 20 minutes. My timing's always off. I don't know. Do you have a timestamp? Because I don't actually know. I'll just go with 5. Woody,
All right.
what is she?
On Monday, is that acceptable?
Hold on. I need to listen to Alessia a little bit.
We don't have to.
I but that's the purpose, is to.
I'm sorry. I actually need to listen to Alessia. If I don't have to listen to anybody else but that man. All right. Let's see. His fanny's always swinging. Where's Benji? Is Benji up here today? Okay. Okay, so apparently Brandon and Jackson were going at it. Okay, I suppose.
The defense has to make a decision as to what you intend to
Yeah, I do have to listen to Alessi though, so that's why I'm going this far back.
provide me so that I can make this ruling. So, all right, next is the Commonwealth's motion eliminate to exclude the expert testimony of Garrett Wing. I know nothing about this person other than your motion just says that all you have is a CV. Does the defense intend to call this person?
I'm going to address that, Your Honor. How would you, I want to make sure I'm within your time constraints, so you want me to stand
Like
up?
2 minutes. Just my first question is, who is this person and why haven't you complied with your reciprocal discovery obligations?
Your Honor, because
Hold on. You guys did not do what? Why didn't you do it? Unless it's some type of tactical advantage. I could not find the link, Brooklyn, unless you want. Why should I go to Law and Crime? Isn't it on here? Because I think there's a spat in front, so this might be it.
Haven't you complied with your reciprocal discovery obligations?
Your Honor, because this witness is a is pending Dr. Crosby. And he's presented because of Dr. Crosby. So it depends upon what happens with that. If Your Honor is ruling on the motion for reconsideration, then we can have a better answer to your question. But that's the purpose, is to address if Dr. Crosby is going to be allowed to testify, and if so, as to what. And we're happy to provide, once we get that determination, provide all the things that I think Your Honor has in mind.
Well, I've already ruled on Dr. Crosby, right? It's just the reconsideration, whether I think I need to rule on it or not. I'd like you to provide the discovery on this, just so we can keep things moving and we don't have to suspend the trial.
We will do so, Your Honor.
All right, so what do you say, Mr. Brennan?
Well, discovery deadlines have passed,
Yeah.
and the Commonwealth shouldn't be in a compromised position of receiving late discovery and trying to deal with it. So I'd like a time certain.
You probably have it, Mr. Alessi, right? You're very well prepared. Do you have all your reciprocal discovery that you need to give the Commonwealth on this witness?
I do not, and not only do I not have all of it, I need to go take a look at to make sure, in light of recent events, that I provide everything to the court. So I can meet a fairly short deadline, assuming I can.
Listen, Alessi is my guy, but I don't know, Alessi, you're kind of disappointing me a little bit here.
Communicate 3 days.
Can we do it by Monday?
Yes.
Is that acceptable, Mr. Brennan?
Yes.
No, it's not.
All right, thank you. So 6:07, Jim, is the defendant will provide reciprocal discovery by Monday, the 24th.
Who did not have a good day? My guy,
All right.
Alessi.
Motion, Commonwealth's motion eliminate to exclude defense expert Michael Easter's opinion of the investigation. So I'll hear you on that, Mr. Brennan. I figured this is probably lengthier than the others.
I'm sorry, Your Honor?
I figured this might be more than 2 minutes, might be lengthier than the others we've heard.
Yeah, I'll watch the entirety of the hearing tomorrow.
The defense would like to call Mr. Easter to essentially testify about his personal opinions of the investigation, and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having a witness come in and vouch for the credibility of defense arguments and essentially summarize arguments. This really, from my perspective, is the role of the defense attorney, to cross-examine the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses. And then the witness would have the opportunity to respond or explain or admit any type failures. This is an attempt to bolster a potential Bowden defense and a third-party culprit defense. It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be. That would be totally improper opinion and inadmissible. They would want Mr. Easter to come in and to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come in, promote the defense theories, tout reasonable doubt, and suggest why somebody else committed the crime. I've done quite a bit of research. This is not a summary witness. This is not a witness that has any relevance other than his own personal opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state. If there are different
Okay, so it sounds like
rules and regulations that the defense will attempt to introduce, that will be a separate.
sounds like they're bringing him in to pretty much attack. What's his name again? To attack. It's the lead. To attack. What's the lead? Proctor. That's what it sounds like. What Proctor should have or should not have done.
Separate grounds of whether they're admissible and whether they can confront the witness. And a witness always has a right to explain or challenge accusations against them. And so I see that this witness is really simply a summary witness for the defense, but not summarizing information that the jury can then digest like information in data records or phone records.
No.
Rather, a summary witness of a witness who wants to come in and give their personal opinions about this case. I don't see any grounds for admissibility for Mr. Easter to come into this case and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have
Yeah, I
directed
called
somebody
it.
to do something different, and inevitably whether he
And again,
thinks-
I did not watch this, but just based off what Brennan was saying, it sounds like, to me, it sounded like they were pretty much bringing him in to say what Proctor should have done or should not have done.
somebody is a suspect that was not pursued. That is all in the province of the defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
All right, who's arguing for the defendant? So I need you to start by telling me what you expect him to testify to.
I can certainly tell the court that we do not expect to seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent.
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, what investigations should look like, what a proper investigation should
How
look
is he
like.
an expert on that? How is that a field and how is he an expert on it?
I'll go
Is
through
it
that.
something he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of courts on issues related to investigations. He was a lead case agent for the FBI for many, many years. He taught issues concerning or taught issues specific to proper investigations and investigative techniques.
So do you have a report and CV and all that material
Yes.
that you can share with me?
Sure.
All right.
I've already shared it with the Commonwealth, but I'm happy to share it with the court as well. If I think I can address many of the court's concerns as it pertains to his expertise and why the law in the Commonwealth allows, in 702, allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, et cetera.
So is the basis of his testimony just crime scene, like collection of
That's
evidence?
actually a good
Or
witness.
is it
Witness
when
interviews.
somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too, both. Because if someone tells you as an investigator, someone else may have done it, you're supposed to follow that lead. That is a proper investigative technique. Of course it is. But it also includes, as the court just noted, things like cordoning off the crime scene, maintaining proper logs, evidence recovery, evidence photographing, logging materials that are moved from the crime scene over to the crime lab, how that's supposed to be done, what types of logs are kept and why those logs are kept, how you bag evidence, how you secure evidence, how you maintain the integrity of evidence, and things of that nature. There is certainly, I would indicate to the court that 702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked at them side by side. They're nearly word for word. And the advisory committee notes for federal rules of evidence 702 is very, very instructive on this particular issue, specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical the scientific and the technical, but extend to all specialized knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education. Thus, within the scope of the rule are not only experts in the strictest sense of the word, for example, physicians, physicists, and architects, but also the large group sometimes called skilled witnesses, such as bankers and landowners testifying to land values. Now, again, obviously, we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the Rules of Evidence 702, the Federal Rules of Evidence 702, clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly, the Rule 702 allows for experts with specialized experience, specialized knowledge, specialized education beyond that of an average layperson, in particular, in a field without, or in a particular field without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative.
What are you referring to, Brooklyn? Brooklyn says, what's the timestamp on your clip from Law and Crime? Are you talking about where we are right now? On Core TV, this is 5 hours, 49 minutes, and 16 seconds. So do you think that I've gone too far?
Techniques and protocols. As the court noted, or as I just noted to the court, he is
Core TV.
he was an FBI special agent for more than 20 years. He formerly coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe.
Come on now.
I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either what I was reciting is either in the CV or in his report.
Okay, so that's
There's something about Bev. Bev, I don't know. Something's going on. Let me leave it there. She's a little rude. I mean, I'm also considered rude for the most part. Or she's frank, rather. She's to the point. She does not have time.
what I need. That would be much more helpful to me.
Then I don't know what more the court would like from
So
me.
I
Do you have
wanted to know specifically what you intend to have him testify on, but if it's in his report,
It's in his, it broadly is in his report. I don't know exactly every
Nope.
question I'm going to ask him, but I can tell the court.
To me, Bev is equally rude to both. I don't even want to say that she's rude. She's pretty brash. She wants, but I also understand it from the perspective of when we started watching today. I think that was Yannetti. That was the first person we listened to. Again, trial court, sometimes it's different where people like to over-explain. But if you ever watch arguments before the Supreme Court, I think really any Supreme Court, with the exception of New York, because New York's highest court is actually the appellate court. The Supreme Court is a lower court. In any event, you have to answer direct questions. These attorneys do not answer direct questions. Today I had a hearing. You guys know I had a hearing, okay? During the hearing, defense counsel is being asked very specific questions. but they want the hearing officer, they want to direct the hearing officer's attention to other information that is not on point or that is not directly related to the question asked. So that's pretty much Jackson. Who's this? Bev pretty much asked him to, give a rundown of what this surprise witness is going to testify to. Instead, he is talking about the resume. So to me, that is not bias. Answer the actual question.
In broad brushstrokes, obviously, we're going to ask him, we've already asked.
But in comparison, if we have to compare, and I've said this before, Bev does have the same attitude as Paige Whitaker. I don't know. I know that I've said it numerous times on these live streams. She definitely has the same attitude as Paige Whitaker in terms of they're kind of no nonsense, but they're also to the point. They don't have time to kiki and mess around, which is different from I forgot what was the judge's name in the ASAP Rocky trial. I don't remember. The judge in the ASAP Rocky trial, he entertained a lot of bullshit, but these women are more, they're to the point. Brooklyn says sorry, it was before the lunch break, 3:30. Okay, is that on Core TV or Law and Crime? Because we can do that, but let's finish this out and then we can jump back.
Him to review. He's reviewed NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to, I expect, render an opinion about whether or not the investigation
Is the last person I want to hear from talking about experts. Like, I don't want to hear from this man. Let Alessi, let Yannetti, maybe even, no, don't let Lowell talk. Maybe let Lowell talk. I don't know. Lowell, to me, she's not very firm. She's a little too shaky.
investigation followed standards and training, best case practices for an investigative.
So I guess that's my question. So without seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see codification of it, or is
So-
it just his experience?
No, it's not just his experience.
I'm trying to book a trip for what is this? I'm trying to book a trip for spring break. Sorry, I'm parenting. But in my mic was disconnected. I'm parenting, you guys. What's up, Jason? I forgot what I was saying. So let's get into it. Okay, so you said Core TV. All right.
Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his opinion, or to render an opinion and a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert that we would use to propound that Bowdoin defense.
All right. Can you get me that report before you leave? Do you have it extra?
I think
All right.
I think we probably have
What
an
do you
extra
mean
copy
you
of it.
think?
Yes.
Mr. Brennan, did you want to respond?
I do.
Super
Mr. Easter was a
random, but I actually hate staying in Airbnbs. To date, I've only stayed in one really good Airbnb, and that was overseas though. But that was a really nice Airbnb, But random. Let's
Respond.
trying to figure out spring break.
Mr. Easter was a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, But as an expert witness in Bowdoin, how many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police. This is just Monday morning quarterbacking, and it's an attempt to bolster argument by counsel so that they can use some type of opinion to lean on when they're arguing to the jury. They should have doubt because of the police investigation.
Yeah.
I don't see.
I mean, to me, that's pretty obvious. But again, I don't know that. Bev addresses again. The hearing has already occurred. Okay, it's taken place, but I did not watch. But again, standard for experts kind of low. The bar here is Vivarito, so we know that standard. The bar is pretty low. But I still. Let me think about it a little bit because, again, to me, this witness, it sounds like he's really being brought in to counter what Proctor did or did not do. That's what it sounds like. That's what it sounds like to me.
Any recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol that wasn't followed, then the defense can see if that state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that will never be able to have an opportunity to explain. Are we going to call in the Canton Police Department again and call in the state police for a second round so they can explain why they chose certain actions that Mr. Easter is criticizing? I don't think this is an appropriate ground for an expert witness. I don't see any cases, I've looked through the state and federal court, that allow an expert to come in on a Bowdoin defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowdoin type witness in any court. He may have testified, but about what? And so I think this is a very dangerous proposition. Okay. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic, that everybody did a remarkable job under the circumstances? What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This invites a debate between people's personal opinions. That's done outside of the courtroom, not in a courtroom. We will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate for expert witness testimony. This is argument by counsel.
You know, very briefly.
They're going to go back and forth. This was, I mean, I'm cracking up a little bit here because this was pretty much my day before the Department of Labor today. It was a lot of back and forth, but ultimately my argument was that an attorney's argument is not evidence. Okay, it's not evidence. But I don't know. It was a crazy day. It's even a crazier day because after the fact, this attorney went on and submitted a whole bunch of case law that I still have to go through. So
I gently disagree with Mr. Brennan. He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well,
you wouldn't be objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Mr. Brennan said, what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have two words. Do it. Do it.
They're loving it. The Reed family is loving it. Hold on. Let's go back because we know that this was a shoddy investigation. All right. I don't even know where they got their training from, but Proctor does not know how to investigate a case. So hold on. I love good moments. Let's go back.
Wouldn't
Hang
be
on.
objecting if they called somebody in rebuttal to reinforce a great investigation.
Oh, no. Oh, no. Mr. Brennan said, what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have 2 words. Do it.
They're
Do it.
loving it.
I'd love that. I'd love
Even the father barely ever cracks a smile. He's loving it.
a shot
Okay,
at that.
so I said, let's take personal.
That's
out
not
of
an
this.
invective. That's not a personal shot at Mr. Brennan. I'm just saying, do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we are entitled to present a defense. And part of that defense, the Bowden defense, is the adequacy of the investigation. And there's no question that a proper homicide investigation
Brooklyn.
is not something within.
Are you referring to Jackson saying, "Do it"? I love it. Okay, I love it. I enjoy witty attorneys.
No, so if
I
you
mean, it's very obvious. I do not. I mean, experts can testify to anything. Okay, or experts are not impartial. I don't care what nobody says, but I just do not foresee any witness or expert getting up on the stand and saying, "Oh, this is, it's kind of routine. It's kind of routine to, put your evidence in cups and all types of things."
you can give me a case site for that, all right? That
Site.
expert testimony regarding a Bowden defense. I've never seen it. I've never seen it in research or anything. So I'd like a case site.
There are certainly cases
You better have case law. You better have case law.
outside the jurisdiction.
Yep, Massachusetts case. If not, you can give me the outside cases, but I don't believe there's a Massachusetts case where this has been done.
We have searched and searched for a specific case in Massachusetts. There, to our finding, there isn't one directly on point, but there are plenty. There's a myriad cases out.
Okay, so he has a persuasive authority, nothing that's binding.
Outside the jurisdiction where investigators
I was getting worried about Jackson because Jackson's words is not worth shit. I hate to say that, but it's not worth shit.
are called.
And this is not only from his lack of candor to the court, but it also dates back to the actual trial, the initial trial, when he goes to sidebar, gives a certain impression to the court about what he's going to ask, and then he goes on and just skates the rules. So
Consistently,
I'm not very fond of Jackson right now,
especially on behalf of the defense, to talk about adequacy of an investigation.
Right.
That is an expert field, one that's utilized throughout the
So
country.
I
all
need
the
some
time.
authority, and the more persuasive the authority, the better chance you have at this. Okay?
Sure.
All right. So I think that's it for the motions in limine.
okay?
Did I miss anything?
Everybody gets a do-over. Is that it?
I need that. Oh,
Your Honor, earlier you alluded to, this is what defense wanted to talk further about the ARCA issue, the Rule 14. You said we'll put that off until the end, if I heard you correctly.
I thought you and Mr. Brennan were going to talk about it first.
No, it doesn't want to go.
Is that your understanding, Mr. Brennan?
Yes, and we have not.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
I regret we don't. We have not spoken.
Your Honor, if I may, on one point on the impanelment,
Sure.
I just know it's the court's preference to have a one-page front and back questionnaire.
Yes.
I was wondering if, in light of the unprecedented pretrial publicity in this case, if Your Honor would consider an additional one-page juror questionnaire that deals with just pretrial publicity. Last month in the Chisholm case, the SJC outlined kind of appropriate
Right.
questions. If in additional to the front and back, there was just one questionnaire that focused just on pretrial publicity, I think that would expedite the impanelment process.
I think that makes sense. Is there any objection from the defense on that? There's been an extraordinary amount of publicity, even far more than the last trial, and so close to jury impanelment. It makes sense to me.
Yeah, I pretty much want to get into. I see Core TV. They have a video about Karen Reed's documentary that she dropped on Tuesday or Wednesday. I'd actually like to watch at least part of that. I don't know that I'm going to sit a full hour or however long it takes to watch it. All right, let's go to 3:30.
Oh,
Let's
I'm sorry, Your Honor, I was looking at for outside cases. No, there's no objection.
All right.
3:30.
So I need the joint questionnaire, and it can be that third page, Ms. McLaughlin. I think that's a great idea. And I was thinking about Chisholm earlier when I was expecting something from the parties. All right. File your questionnaire, file your.
Okay.
Independently admissible.
Is this it? This is 3:29. Is this where you'd like me to be, sir? We need to check up on Benji. Hold on. Brooklyn, is this? I'm getting distracted. Is this where you want me to be?
And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been downloaded it himself.
Hold on.
And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr.
Brooklyn, let me know if this is the right spot or not. Okay. Because I can certainly, I want to listen to Alessi. I'll listen to Alessi by myself when I'm at work tomorrow. I'm just trying to find the proper spot of Brandon and Jackson going back and forth. This might actually be it. Is this it? This might actually be it.
Welcher. Actually,
I might actually start ironing while I'm on this live. I might start ironing because this is it's kind of past my time, and I don't want to
downloaded
be
the
late.
text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't.
I need to go back. I need full context. I need to know who.
All of these standards that Attorney Lisi is insisting on are excused, but if they don't like the opinion, all of these standards that Attorney Lisi is insisting on are excused.
His name is Lisi. I thought he was Alessi. I don't know.
But if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they give. They both have a different opinion about the taillights causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis. And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked at the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until. We have all that evidence, and as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his study. This is what he does. The demonstration at Meadowbrook, John O'Keefe's house, is depicted by measurements which has been provided, science and data, by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging in the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses. The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right tail light. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken tail light, and it shows with great continuity the height, location of that broken tail light, and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered as evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to present the demonstrations to support the opinions.
Hold on. Why does this look like Turtle Boy? Am I mistaken? That actually does look like Turtle Boy.
As corroborative evidence of those opinions rather than just naked opinions.
Isn't that Turtle Boy?
And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCA information. It does concern me delaying that information because, as Attorney Alisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well. And if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery.
Yes.
Okay.
May I be heard to respond?
Sure.
Thank you.
Like with Dr. Welcher's report, what Attorney Brennan did not say is even more important than what he did say
Listen, I like Alessi.
moments ago.
On point.
He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data, quote. Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan. Attorney Brennan said falsely just now that the ARCA report does not set forth the methodology.
That's not right.
There are 14 footnotes in the ARCA report. I just looked at them again. Footnotes 1, 2, and 3 tether the methodology of the ARCA experts to the literature. The methodology is documented. I do not understand how an attorney can get up
Why are you raising your
and say a report doesn't have something without having a basis for saying it
Okay.
on a key issue that is disputed. Attorney Brennan also falsely stated that ARCA did exactly what Dr. Welcher did with regard to medicine and medical issues. That is completely false. ARCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then so the unknown is the force, the F in the calculation. What is known is the M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You then take the acceleration theory, even assuming the theory of the Commonwealth, which we can test, which is—
When you say that it's him, are you saying that it was actually Alessi and Brennan that got into it as opposed to Brennan and Jackson?
15 miles per hour or 24 miles per hour, you multiply the mass times the acceleration and you get a force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis. The ARCA experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what ARCA did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, this is
Oh,
what—
never mind. I see. You're saying it's Turtle Boy. You're saying it's Turtle Boy. Because I looked at him. I was like, that looks like Turtle Boy. That looks like little Turtle Boy. Okay.
he
Yeah.
does, referring to Dr.
Now, I mean, the only time I've ever seen what Turtle Boy looks like, it was during the juror interview that we actually watched together. Because I was just, I was going through a bunch of clips that were recommended to me. And it looked like Turtle Boy and Karen Reed were actually, apart from being in the same courtroom, it seemed like they were both about to address the court. Let's see if we get into that. I need to get going.
Welcher.
I need to start
The
ironing.
question is not, is this what he does? The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfying the Dalbert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted either in court opinions, which the court could take judicial notice of, or
I like the way that Alessi argues.
in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Dalbert factors, I covered that in my presentation in the beginning. I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries, I understand what Dr. Welcher did. The question is not what did he do, but is it accepted in the medical literature? So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature. He finally concluded by saying, this is within the bailiwick of Dr. Welcher. I don't know what this is, but bailiwick is a tautology. It doesn't say anything about whether what he did is rooted in the literature or that it satisfies the Dalbert factors. So in conclusion, Your Honor,
I'm tired.
I go back to Rintala. I go back to Meeks.
What
I go back to Case of Caravan.
Oh, Council Benji is here. Yeah. Hope you're okay. Okay. I know you're probably not okay, but I hope you're okay.
The Commonwealth has not today, not before, this is their fourth time, has not satisfied what the Supreme Judicial Court requires in these instances. And what it has come down to is the defendants, which stands in a different position. This equivalency between ARCA, I've shown, and it's easily documented, the court can see it, that contrary to Attorney Brennan's false statements, ARCA did cite to and tether their methodology to the literature. But when you have a defendant on trial for the seriousness of the charges here, to have no methodology, to have no tethering to the literature, that's, as Your Honor knows, the gatekeeper's function to stop those opinions from going to the jury, to ensure not what the defense has created, but what the Supreme Judicial Court has created, which is the purpose is to allow for cross-examination and a fair trial. They haven't satisfied their burden. They have the preponderance of the evidence burden, and the consequences should be borne by the Commonwealth, not the defendant.
Okay. Go ahead, I'll hear a quick response.
Okay, who's going to start?
Regrettably, I know Attorney Alisi has decided to join the fray of disparagement. Now, he has said 3 times that I've made false statements. This is
I knew Brandon was going to start off with something. Sorry, I need to go back. I like listening to Alessi, and Brandon go at it. I really do. But who do I like listening to more? I don't know. They kind of have a similar style.
regrettably, I know Attorney Alisi has decided to join the fray of disparagement. Now, he has said 3 times that I've made false statements. This isn't the first time that Mr. Alessi has tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered by the media, and they want to create a sense to dehumanize anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence.
Listen, I like listening to this man talk.
There's no place for it. 3 times. This follows when he made representations.
Okay, Brennan, hopefully you actually address what he says as far as methodology, as opposed to, just, I don't know. I guess you do have a right to respond, but in whatever manner you find fit.
Representations in court that Brennan lied 10 times. We found some of those transcripts, and I took enough dignity not to mention it, because I didn't think I needed to, that the transcripts were not even accurate. Mr. Alisi was actually wrong when he was claiming I was lying about reading reports.
Sheesh, okay.
Now, I don't want to stand up here and have a dispute, but when you use words like false statements as an officer of the court, they better be supported. That is a strong statement to repeatedly make, and it's a tactical one. It's purposeful.
Okay.
Attorney Alisi is joining the fray, and that is all part of the strategy here.
So it sounds like, he once upon a time distinguished Alessi from the rest, and now Alesi has joined the pack. I personally, I still like Alessi.
Now, if you look at page 13 and 14 of Dr. Welch's report, perhaps that was missed in the review. There are resources in that report that number 26 different items of resources. And so if we're talking about support and tethering, it is at the end of the report. It's not footnoted like ARCA, it's at the end of the report. It's all there.
Oh, okay, that's
All
it.
right. Thank you. So we're going to move on to try and get some motions in quickly. The motion regarding the chalks, is there an objection to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual?
Brooklyn, I hope you don't have me watching this whole thing. Where's the actual slide?
Presentations and chalks prior to using.
Or
No
maybe
objection.
here.
Okay, thank you. 583.
The fireworks. Do I need to iron and go to bed?
Is there an objection to the Commonwealth's motion eliminate to allow the expert celebrate demonstration? We had it before. Is there an objection to that from the defense?
Yes, Your Honor.
Okay. All right, is this something that can be done quickly, or is this something you need more time on?
15 to 20 minutes, Your Honor.
All right, so we're going to have to table this. We may end up coming back tomorrow.
I can do
Tomorrow?
it unless, you tell me what Your
No,
Honor's
let's see what we can get before the luncheon break. The paper number 585, it's the Commonwealth's number 11. Motion eliminate to admit the victim's out-of-court statements relating to John O'Keefe's state of mind, the quals, bins, types of cases. So is there an objection from the defense on that? If there is, I'll hear it quickly from the Commonwealth on its motion.
There is, Your Honor.
Okay, so I'll hear you on this, Mr. Brennan.
Evidence of
Leda and I missed the bus this morning. We missed the bus this morning. And I kept telling her, I'm like, we need to go, we need to go, we need to go. And I don't know what she was doing. I do not know what she was doing. When we went out there, and here's the thing. This is the second time we've ever missed the bus. The first time was, I believe, last year. Okay. It's the same bus driver. This guy does not wait around. He does not give you 5 minutes, does not give you 30 seconds. We started running after the bus after the fact. I was like, girl, I'm just going to drop you off. Because my plan was to be in the office by 7, but that did not work out because I had to drop her off and I actually have to drive past my job to get to her school, and school opens later. But yeah, I have to set my alarms because we cannot be late tomorrow.
Mr. O'Keefe's state of mind is particularly relevant in this case. In addition to the charges, this has a domestic aspect to the case. We know from his statements that he was in a relationship with the defendant. We know from the statements that there was a tumult in that relationship, and many of those statements are reduced to writing. The state of mind of Mr. O'Keefe is reflected in those statements. There was no time or reason to fabricate. You can tell by the content and the volume of them that there is a legitimacy to them. And it is clear based on that and other testimony that he was in the course of attempting to end the relationship with Miss Reed. And so his statements, especially over the course of the day of this incident.
All right, so what's the time frame? It's so over the course of the day.
And that girl, Bev, is, like I said, I don't know if she's rude, if she's brash, if she just does not have time, but there's something there.
I realize that the Aruba incident is too remote and you're not using that, but what's your time frame for me to be able to evaluate
As
this?
far as his messages, I will
Or
look.
the statements or the evidence that you're
I
trying
was
to
about to say, just to answer the question, or maybe he's in the process of answering the question, or he doesn't know how to answer the question, but answer the question.
put in under this doctrine.
His niece would testify, as she did
I
in the
thought
last
she asked for the time or the time frame.
trial about the tumult in the relationship.
Okay.
And we'd introduce the same text messages that we introduced at the last trial, reflecting Mr. O'Keefe's state of mind about the relationship.
Okay.
And there would be nothing different from the last trial, other than the fact that we are not going to pursue the Aruba information. So it is actually a narrower time window than before.
Okay. All right. I'll hear you, Mr. Jackson.
Thank you, Your Honor. I may be a little more brief given that explanation by Mr. Brennan than I intended or anticipated. I will say that where the Commonwealth's motion fails is in its explanation as to the relevancy and how it comes in under a state of mind theory. These are obviously hearsay statements that in some cases they are multiple hearsay statements. or potentially multiple hearsay statements, John O'Keefe's state of mind is irrelevant unless there is a specific admissible evidence that he communicated those statements, and we'll have to sort of take them as they come, given I don't have the full breadth or an understanding of the full breadth of the information that is being sought. Mr. Brennan just indicated it's going to be consistent with the last trial, so that gives me some target range. But without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Miss Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent
Right, that's
with.
what we were talking about, the bins, calls, those points that need
Correct.
to be made.
And that's what I'm getting to. With that last point, and to drive this point home, that's preposterous. The idea, there is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her, or he was mad at her, or he was angry at her about something, some incident, some specific thing having to do with feeding the kids donuts or not feeding the kids donuts, or they had what was considered and what was testified to in the first trial as a very normal row or argument about something as insignificant as that. The fact is, the state of the evidence is that on the night in question, it's uncontroverted by even the Commonwealth that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statement that went uncontested, that they were affectionate, they were happy together. They were described by basically everyone on the Albert side, the McCabe side, as well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening. And they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty clear that through this testimony, or through this rubric of bringing in John O'Keefe's state of mind, the Commonwealth really wants an opportunity to call one or more or several witnesses who will basically say he wanted to break up with her, she was not a good girlfriend, he didn't like her. That is an assassination of her character. You couch it in whatever terms he wants, but that's really what it is. These witnesses will have no corroboration, we expect. I'm leaving the text messages aside. If there are text messages between John O'Keefe and Karen Reed, that may be a different analysis, but certainly where it comes down to the witnesses, like the niece, they'll have no corroboration or no documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Reed with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in this circumstance. Even if the evidence was that he had discussed breaking up with other people, there are two major impediments to the Commonwealth's request.
Okay.
First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence that was imparted, or those specific conversations were imparted to Miss Reed. The state of the facts very clearly show the opposite. If we look at the circumstantial evidence, the videos of Miss Reed at both C.F. McCarthy that night, as well as at the waterfall that night, showed the two of them getting along, completely inconsistent with two people who were talking about breaking up. John O'Keefe wanting to dump her, and her knowing that she was going to be dumped, which is what the Commonwealth is generally suggesting. And second, there's absolutely no evidence that even if she thought that John O'Keefe, if she was aware that John O'Keefe was unhappy in the relationship, that he might want to break up or in the relationship, that would have been a catalyst for murder. And that's where the rubber meets the road in this analysis. That's what the Commonwealth has an obligation to prove before this evidence is admissible. and that's a ridiculous stretch. They'd been together for about 2 years, notwithstanding the prior relationship many years earlier. She had her own career. Karen Reed had her own money. She had her own life. She had her own job, had her own house. She was not dependent upon John for anything, not for money, not for room and board, nothing. They were, at the end of the day, just dating.
Okay.
The fact that she had some text messages with other individuals, or an other individual, Higgins, is actually evidence that she knew she had options, and John O'Keefe likely knew he had options as well. Both
What on earth? What on earth are they even getting into right now?
of these individuals were not tethered to each other in a way that if one would one was going to murder the other one. And that's what the Commonwealth would have to prove to make this admissible. There's no suggestion in the facts that Karen Reed would kill John O'Keefe.
Brooklyn, unfortunately, I cannot overlook that. Okay. I do not tolerate improper conduct, be it from the prosecution, the defense, law enforcement officers. I've said that over and over again. That's not something I can ride with. So it doesn't matter to me because he's tainted. Okay. He's left a bad taste in my mouth.
Rather than simply break up with him or allow him to break up with her, and they both go on their own way.
Bring a lesson back.
And there's no evidence that she was angry with him that night before she got out of her SUV. All of the evidence that we have, all of the uncontroverted evidence that we have, establishes exactly the opposite. They were a loving couple out one evening, having drinks with friends, in a good mood, and happy with one another. We cite a case called McGraw, M-A-G-R-A-W. And just for the record, I'll state the site. I think it's at 426 Mass 589. And the McGraw court provided a very defined quote that I think is illustrative for our purposes, Your Honor. Quote, a murder victim's state of mind may be material to the defendant's motive, but only if the defendant knew of the victim's state of mind, and most importantly, the court's words, not mine, and most importantly, would be likely to respond to it. The best evidence that this second prong cannot be met is the fact that the Commonwealth will attempt to bring in these prior statements of John, which, if believed, Miss Reed never acted on. In other words, they're going to bring in prior statements to say she would necessarily act on it, and act on it in a violent way that would take someone's life. But at the same time, they're stuck with the very clear fact that if in fact that's true, and it was imparted to her that he was unhappy in the relationship, she never acted on it, not once. And the moment that we do have frozen in time that we can go look back on is the night of January 29th, or the evening of January 28th, going into the early morning hours of January 29th, in which they were both getting along perfectly well, completely in opposite of what the court in McGraw defines as necessary for that sort of evidence to be admissible. The reason that the Commonwealth's theory for admission doesn't make sense is because it's not really their theory for admission, I suspect. I suspect that it's more that they would like to have someone or some people get on the witness stand and assail Miss Reed's character, make her look bad, and say that she was either a bad girlfriend or that John was not happy with her. Okay. It's an attempt to inflame the jury, to make them dislike her for something that has nothing to do with the evidence that she hit him with her SUV on the night in question. And it's a very transparent attempt. We strongly believe that this attempt does not meet the evidentiary standards that are required. The Commonwealth cannot meet those standards, and pursuant to McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Okay.
All right.
Quick follow-up.
It seems the thrust of the defense argument.
And I don't know where he gets his one-liners from, but I don't know. It's a different style.
It seems the thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth, is that they were lovey-dovey and got along well that night. Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On
Look at Turtle Boy. That's why they don't want you in the courtroom, Turtle Boy. Turtle Boy is making faces as if he was personally there that night. You don't know these people.
and got along well that
Just
night.
look over here.
Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On
Yeah,
2020,
I don't know Turtle Boy, but unless you are actually really there and know these people personally, uh, I could understand your reaction. But other than that, we are mostly spectators.
transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes. She was asked by Ms. Voss on June 20th, 2023 about that night or the day before. And she says, I was temporarily frustrated. It wasn't an argument. She also says to Ms. Voss, were you worried at him or pissed at him or both? I was pissed.
Why the hell was she talking? And that's, she was talking before. She continued to talk even as trial is about to go on. I don't understand why people do so. Like, why do people talk so much? Why are you doing so much talking?
I fell asleep.
Like, lawyer up and keep him. Why are you talking?
Now, in addition to her anger, she specifies some of the tension. We heard from.
So Benji says that today is a better day for me. How's your day? It takes time. It takes time, Benji. Okay. My day was very stressful. Yeah, incredibly stressful. Yeah, it was stressful. I had a stressful day. Because I've just a lot of things were just being thrown at me. I had that hearing. The defense attorney waited until the 11th hour for them to share their Rule 14 answer, because obviously they don't want to give me a lot of time to prepare, even though I filed my pleading, I don't know, last month. Apart from that, I had another hearing, I don't know, a few weeks ago, and the Department of Labor ruled in our favor. Defense is not happy, so they filed a motion for reconsideration. So that's something else that I have to address, and a lot has been going on, Benji. But I'd rather complain about these aspects of my job than not have a job. So I'll deal with it. I'll deal with it tomorrow. And if I'm still stressed out by tomorrow, then the following day and the following day, and so it goes. Brooklyn says, would you be surprised if Turtle Boy and Karen Reed had something going on that night? Wait, what? What? Brooklyn, where are you getting that from
The testimony.
I'd be very surprised. Again, I don't know much about Turtle Boy. The only thing that I watched was that one interview with a juror, and then when his name was first brought up during the first trial. Other than that, you guys know I don't keep up with these folks' personal lives. I try not. I mean, I don't have social media, so unless the algorithm gets to me.
Testimony of Jen McCabe, that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. This is minutes before we allege the collision happened. And so in the interviews that she has provided to these different outlets, she discusses the fact that she hears this information and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision.
Okay.
And so we have statements from the defendant herself that show the discord in the relationship, the anger, being pissed, the motive. without reading them because it's unnecessary. There is substantial corroborative evidence. Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time, moments before John O'Keefe's death. And so all of this should be admissible. It's all supportive of each other.
Your Honor, if I could just correct the record very quickly.
Sure.
If anything Mr. Brennan just said was true, he might have an argument. My goodness. It's important to get some of the facts right. You got to get some of them right. The conversation that he just referenced with Jen McCabe was the next day. It was the next morning, not minutes before the collision. He's read the every time he stands up, he says, "I've read the I wasn't there. I've read the transcript." We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found, after he didn't come home.
Well, I'm still waiting for the fiery moment.
I'm sorry. I just need to correct.
I'm sorry. I was talking to my client real quick. I'm not quite done.
I just need to correct. I'm sorry. I just need to correct.
I'm sorry. I was talking to my client real quick. I'm not quite done. This was during the time after 5:07, after the SU.
Is that it, Brooklyn? Brooklyn, I hope that's not it. I hope that's not it. What? Brennan getting to the podium? That's
He leaves. We see One
nothing.
Meadows and Jim McCabe and Kerry Roberts get together. And as they're looking for them, as they're looking for him and searching for him, that's the point at which they have the conversation about being some other woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact. The other issues concerning Karen Reed's statements about being upset, or in Gretchen Voss's words, were you pissed at him? It was in context of when. When were you upset with him? When he didn't come back out, when he didn't come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever, no evidence in the record. I want to make this as crystal clear as I can. No controverted evidence.
Somebody's
no
always coughing.
suspect, no evidence at all that John O'Keefe and Karen Reed had a single crossword that night before he ended up missing and she went home. Before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out. Zero. The only evidence that was propounded throughout that entire day was hours and hours earlier that morning, dealing with, did you feed the kids donuts? And yeah, I did.
What's up,
No, I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough.
Just said, what's going on? We're just going through hearings. We're going through hearings. That's pretty much it. Brooklyn has me going down a rabbit hole. I'm waiting for fireworks. I still have not seen fireworks. But how are you? How have you been? It's been a minute.
To enrage anybody, it's ridiculous. And the evidence that it didn't enrage anybody is the fact that they ended up later that night together in a lovey-dovey environment.
It sounds like tough.
Getting along
to
fine,
me.
getting along wonderfully. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial.
I don't like that last statement though, when he's saying that, this would have been the type of information that that she murdered him for something. It kind of just the way my mind works, it sounds like Jackson is saying, well, she took him out, but for another reason, and not the reason that the prosecution is, alluding to.
It's probative.
Yeah, I don't like that.
Okay.
Okay. So, fever, pretty much same routine. Okay, work, home, smoke, eat, and go to sleep. Well, good to see you.
Before accusing somebody of getting it wrong,
Here we go again. Like, okay, let's listen to Brandon.
before accusing somebody of getting it wrong, the person accusing should be right.
Woo!
I know
Sorry, hold on. I, I, I personally like these one-liners. I like these one-liners. Okay, let's go. Come on, Brandon. Let's go. Okay, say it again.
before accusing somebody of getting it wrong, the person accusing should be right.
All
I
right.
know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't listened to the interviews.
Sheesh. Hold on. Wait. I'm sorry. I'm having a little too much fun. Okay, come on.
Somebody of getting it wrong, the person accusing should be right. I know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't.
I've been good, Fever. Just working, a little stressed out. Defense attorney's giving me a hard time, but I have to keep it pushing. And my baby, she's fine. She's asleep. It takes her a while to fall asleep, but she's definitely asleep. Okay. That's fine. We just appreciate you being up here, Fever. But we're still on Karen Reed on Monday. Is that the 25th? Let me look at my calendar. I have no sense of time. When is the 25th? Oh, that's Tuesday. Okay, so Tuesday, Karen Reed will be back in court. On Monday, we're actually gonna start. I think let's okay, the 24th, got it. Yeah, Monday, we're probably going to touch a little bit on Lori. Okay, Lori Daybell, Laurie Vallow, I believe is her other name. I don't know if she has a hyphenated last name or something's going on. But we need to talk about Lori a little bit because she's representing herself. She was in court on Monday or Tuesday. I don't remember. I watched part of it, but not everything. But what I saw so far was very interesting. To me, I was actually really impressed with Lori a little bit. A little bit. Not she still should have hired an attorney or asked for a public defender, but she was doing okay.
Listened to the interviews or read the transcripts. Page 88, line 22.
Okay, so I don't know. O'Keefe's mom, it seems like she's a little she's tuned in.
Right. I know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts. Page 88, line 22. Not the next morning. When Jen was navigating John to the Alberts, she said it's near Ashley's house.
Oh, she's loving it. O'Keefe's mom is or Mrs. O'Keefe. I'm assuming that's actually her last name. But she's loving it. She's like, come on, Brandon, get him.
Transcripts. Page 88, line 22.
I should be ironing.
Not the next morning. When Jen was navigating John to the Alberts, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Similarly, page 92, line 1.
Okay, I don't know what the hell Karen Reed's mom has going on.
Totally contrary to what you just heard. Totally. There was a woman who was a mother to kids that were close to John's kids who lived very close to the Alberts. In fact, when Jen was navigating John to the Alberts, when I was driving, she said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with.
Who's Peggy, Brooklyn? It's Lori. I'll put her up here before we go. Let's see. She is very bold. That girl. But here's the thing. I guess she's in her. I don't even want to say part of her reasoning, maybe because she's already serving a life sentence. It's wild. The first trial, she was convicted for taking out her children. I did not watch the trial, but I was aware of the trial. But I typically stay away from cases where kids are minors. Even the Medi Soto case that's, that's in Florida. I mean, when the girl disappeared, and as they were investigating, as news was breaking, I was following. Right? I mean, I do follow crime every single day just to see what's happening in the world. But I don't. When it comes to trials, I don't watch stuff like that. So yeah. So when Lori first went to trial, I did not watch, but I was aware of what was going on. This time around, though, she is on trial for offing the husband, so I'm definitely watching. And then she has another trial for attempting to off her niece's the niece's husband. So Lori has a lot going on. Okay, so Peggy, got it. What does that mean? Her first name is actually Margaret? Okay. Yeah, she's already doing life, but that girl was talking about her paralegal. She had case law. Um, she was talking about hearsay. So very exciting. Anyways, let's get into these folks because I have to iron. I honestly could have ironed, but I'm too invested in this.
Their husband. Not my words.
Yeah. Okay, they're fighting. The boys are fighting. The boys are fighting. She's loving it. She's really loving it. Big shout out. Okay.
She said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with her husband. Not my words.
Jeez, okay. This was actually worth it. This was actually worth it, Brooklyn. I probably could have skipped over Alessi a little bit.
All right. So we're going to break. We've got a lot of ground.
Listen, I've said it before, I like Brennan. Okay. Brennan, he's my type of prosecutor. He's to the letter type of prosecutor, and he knows his stuff. And what I actually like about Brennan is his demeanor. Okay. He's not, I guess that's why I like Alessi as well. They're pretty calm and collected individuals. As far as, again, let me leave Jackson alone because Jackson has really left a bad taste he's left a bad taste in my mouth. But he got up there, talking about how he was actually present during. Why was he having why was his client? Why did he allow the client to be interviewed? Now I have real questions. If you're present, I don't know. I don't know. That doesn't make sense to me. But there are a number of ways of defending criminal defendants, so that's just his way. But in any event, he got up there, was a little, aggressive, maybe insulting in a sense, and it turns out he wasn't right.
To still
Maybe
cover.
the transcript.
I
is wrong.
suggest
I
that
don't
we
know.
take the personal attacks completely out of this.
Okay.
We're going to break. We've got a lot of ground to still cover.
Okay.
I suggest that we take the personal attacks completely out of this. Hold on. Both sides. I want to get through these motions today. If we don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions. Leave all the attacks, all the falsehoods, all of that. Leave it all aside. Let's focus on the motions and get through this. So I'll see everybody at 2 o'clock.
Your Honor, if I could say one more thing. Jim, as the court ponders this last issue.
I'm not even thinking about it for the next hour. Let's leave it.
And that's what I've said about who's this? Bev. To me, Bev is her brashness. Some people consider it to be rude. This is somebody trying to get through the trial. But before they can even get to the trial, they have to get through the hearing. They are on a time limit. And I've said it already in this live stream. I've said it in other live streams. To me, she has an attitude that is similar to Paige Whitaker. And I do not know if it has something to do with them being women. What I mean by that is, in a sense, I mean, they're really presiding over cases that have white men on both sides. And, sometimes in the legal field, it depends. There are a lot of factors. But I wonder if they have this sternness to them because they are women and they want to be respected and they pretty much have to lay the law down. Okay, so Fever said, yeah. All right, Fever, we're going to do that. We're going to do that on Monday, okay? Let's see. Is that the end of it? I quickly want to take a look at one more thing. One more thing before we leave, okay? I just want to do it here because if I don't do it here, I'm probably not gonna watch it. So okay, this title got me, okay? The title got me. So let me see if
They're very well aware
hopefully it's not clickbait. Hopefully it's not clickbait.
of that person's name. It may be, but I don't know that, and that's why I've refrained.
Let me
on
ask
the
you
name.
this, counsel. Does the name of the intermediary appear in Trooper Tully's
I was about to say, like, who's talking? Wait, what did I miss?
affidavit, either
When was this?
in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought.
Oh, okay. So this is between, not between, because they're not against each other. So this is, I suppose, the hearing that has to do with Karen Reed and Turtle Boy. Turtle Boy, got it. I just had to read this little description here. Okay, so apparently they do have other judges in this courtroom, unless all the courtrooms are just, mirrors of each other.
Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove and that they have the reports that have been generated.
Has the underlying data from the two phones in question been assembled?
Hold on, what are they saying here? So they are saying that Brennan argued that sharing phone records between Reed and blogger Aidan Kearney could indicate her consciousness of guilt. What, like, I'm trying to figure out.
Understand that
There's already a trial going on. Why are they? I don't know. I'm not saying that criminal defendants should not go out and have a pizza or whatever, when they're when they're charged with a crime. But I think you don't want to have or create a trail of evidence.
I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Kearney's phone, is that there was a relationship between Karen Reed and Mr. Kearney, in which Ms. Reed would provide.
Okay, so I suppose this is why Brooklyn asked me a prior question. Hold on. Where's that question? I cannot find it. Brooklyn asked me, or at least he made a statement. I think he said, would I be surprised? Hold on. Okay, so Brooklyn said, would I be surprised if Turtle Boy and Karen Reed had something going that night? Well, I don't know. Jason says that Karen's team basically crashes the party. I want to see this.
Information indirectly to Mr. Kearney. That information would then be reviewed by
Kearney?
Mr. Kearney,
I thought it was
posted on social
Karen
media,
Reed.
and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is
I do not know why people go out and create problems for themselves.
extraordinary detail on how Mr. Kearney
I thought it was
targeted
Kearney.
witnesses in Miss Reed's case, with the express purpose, according to Mr. Kearney, that this trial of Miss
They are in Massachusetts, so maybe it's a different pronunciation.
Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle.
What? Hold on. No way. No way. This is, okay, it says 4 hours ago while I was working. But this is, I'm just looking at my phone here, and from Indisputable with Dr. Rashad Ricci, they're saying that a man is arrested in connection to horrific deaths of 2 Black twins. These are, again, my algorithm, they just recommend all the crime stuff to me. But I watched the news report, and they pretty much talked about how these twin boys were found in some mountains somewhere in Georgia. They had missed their flight, and I believe, wasn't the police reporting something along the lines of, or at least there was a suggestion that these kids did this to themselves? Well, somebody's arrested. Why? I'm going to watch this when I get off here. Why?
So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
Wait, what's the
I'm not-
question? I'm getting
Or
distracted.
the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023. 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have
All right,
absolutely
here they
nothing to
come.
do with
Let's be
communications
reading the
between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney is attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team, unless they have standing in this.
I don't know. The way that maybe I was just imagining something else, because by this title, I don't know what the hell I was expecting, but I was expecting something.
Kearney, so I'm asking that Mr. Kearney is attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team, unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're.
Can you state your name for the record,
Of
please?
course, I'm sorry. Alan Jackson on behalf of the board. We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number.
Okay,
or
so
if
what are you doing at council table?
it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Canoni, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on.
Okay, who's this? Who are these people? I guess that's his family. Kearney's family, Turtle Boy's family.
Ms. Reed's case number as it pertains to her rights and the
This
issue.
It is,
meeting is being
counsel.
recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan. and
No,
Mr.
the
Carney.
page is on the court is on a certain page. You're the one that's kind of, it sounds like you're lost.
The case number that was called was the Commonwealth
She has good shoes on. The attorney, Little.
versus Karen Reed.
00117.
Okay,
That's correct.
then she needed to be here, and she has a right to counsel, and we have a right. We believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that that's, yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to
The judge is asking difficult questions. The judge is asking difficult questions. I've been up here for 2 hours. I really need to go. Hold on. But this got really spicy.
the prosecutor asking for information in her case to move forward, her consciousness of guilt, et cetera.
Those are evidentiary issues, counsel,
Correct, but we,
which can be dealt with at a later time. Those are, what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a lamprin.
I know, Brooklyn, if you're still here, so do you consider this judge to be biased as well, considering that he has a pretty firm tone and he's not handling Alan Jackson with kid gloves?
Hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I
This
understand,
is,
Your Honor. And respectfully, I don't necessarily disagree that from an evidentiary standpoint.
These folks literally crashed. They crashed the hearing.
Disability standpoint,
They
that can't
came in as a pack, disrupted everything.
be dealt with at a later time. But the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever.
I need to take
I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Carney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Carney's case. So she has to have a right to be heard.
counsel,
That's our belief.
counsel, this motion's been pending for a week and a half now. I
Correct.
don't have any opposition from you. I don't have any submission from you.
Yeah, I don't even
We
know.
intended to submit oral.
You
I don't have
did
any
what?
submission. Motion's been pending for a week and a half now. I
Correct.
don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're
And did you
prepared.
give the court notice of that?
We did to Justice Canoni,
Okay.
day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues.
I don't want to hear from Little again. Like, give Alessi, okay? Give everything to maybe what's the other guy's name? Yannetti a little bit, but Alessi's my guy.
Mr. Brennan, bring it.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back.
And are these
I
two
will-
these two smirking at each other? What's going on? I don't know. I have to let me find Brooklyn's comment again. Okay, so Brooklyn says he has never seen such a shit show. There's a lot. These are distractions, because here's my thing. So if, again, we don't have the very beginning of, I don't know when they started recording. Maybe there's a live somewhere. But if Jackson was of the opinion that his client had to be in court for this hearing, why are they showing up in the middle of the hearing? Why are they late? Unless they purposely or intentionally, wanted to disrupt the proceedings. And I don't like, you guys know, I don't like dirty tactics like that. If you actually do have a legal argument, then make the legal argument. You should not engage in any dirty tricks unless you really have nothing.
Be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes its ultimate ruling, and once Mr.
I still do not understand how Jackson was just allowed to be up there addressing the court while Brennan was not done. What are they doing? What are they doing?
Brennan is finished, I think we have we should be provided an opportunity to be heard.
I'll consider the request.
Judge, I have no objection procedurally if counsel wants to join in my file.
Of course you don't. Of course you don't.
That's an issue in terms of the file. So, just put it
Thank
down.
you. Thank you,
Well,
Attorney
Your
Brennan.
Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at council table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
Okay, now they
So-
sit down. This is so chaotic. Sit down, walking in like bosses, stand up, and then sit down again. They definitely crashed this. I need to retitle. I would like to retitle the video, but I'm not going to do that. I don't have time.
ADA Brennan, with the court's apologies for the interruptions. The crux of the issue, as I see it, with regard to relevancy
No, is that my
and the
computer
Commonwealth's
or-
burden at this stage
That's all
to
fine.
show that the requested materials are relevant
What's this judge's name? Brooklyn would know.
involves the breadth.
Honestly, when I clicked on this video, I was expecting Bev Canoni and pretty much an extension of, or at least a clip from today's motions before her.
Of what has been requested. And perhaps
Okay, I don't know. Is anything else happening? Nothing else is happening. Let's go back. I'm sorry. You guys know I love the mess. Let's go back. We're gonna go back.
affidavit in support of the search warrant, it calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023, 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos,
Baby, look at Alessi. He's out there leading the pack.
things that have absolutely nothing to do
I don't
with
know. It seems like Alessi was already seated though, because I don't see him carrying, anything. Not a coat, not a briefcase, not a legal pad, not a pen.
communications between the Mr. Kearney and the defendant.
This is
So
so chaotic.
how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Carney, so I'm asking that Mr. Carney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team unless they have standing in this.
Your Honor, we're-
Let's go back. Hold on. She said what?
By Ms. Reed's team unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to.
What a mess. Very chaotic. All right, so let's see. Brooklyn says the judge already released his ruling tonight. Jason said they didn't put Turtle Boy's hearing on the document. What do you mean? Document or docket? Docket publicly, I heard. Brooklyn said it was denied. Phone logs are coming in. Send me the link. Send me the link, Brooklyn, because it's past my bedtime. It's really past my bedtime. It's been a while since I've been up this late, but this was really, really messy. And I had to be here. I had to watch all this mess. Because it's a very chaotic. Yeah, Brooklyn, please send me the link. Send me the link if you can. Only for a certain day. Jason said messy. Yeah. No, I definitely love Alessi. That's my guy. But this is some court TV, not even court, not like the channel, but when they have these overly dramatized, what is it, series about courts, this is the type of stuff you see. I guess this is a real court, but these are not things I've not, again, I've said over and over again, I have not worked with attorneys that behave this way. Did I work with some people that were a little cuckoo? Yeah, of course. Because even sometime, was it this week or last week? It must have been last week. Last week, every once in a while, I like to, see what my colleagues are up to. Like I look at my prior public defender offices and just see if there's been movement to who's heading the office, who's this. I worked with some guy that was, man, that man was batshit crazy. That man was so freaking crazy. Um, I don't know what the hell his deal was, but he had something going on. But he no longer works for that public defender's office. I was gonna tell you guys the region, but I'm not gonna do that. I'm not gonna do that. Because I actually had a nickname for him, and the nickname was tied to, the county, the county that he's from. But that man, he was batshit crazy. Anyways, everybody else is still at that office. He's not. I have no idea what happened to him. But that man he was really crazy. And I've actually, because have I seen him at trial? Let me think. Have I seen him in court? I've seen him in court, but I do not know that I've watched any of his trials. But that man was really crazy. Okay. Oh, really? I did not know. I did not know that, the ladies have been crushing on Alessi, but I like Alessi. That's my guy, okay? He's a little nerdish or whatever, but he has charm. All right, folks, I'm calling it a Lori. Hold on. Lori Vallow. So that's how you spell her name, Brooklyn. So on Monday, we start off with Lori, because so far to date, I think she's the best pro se that I've ever seen, with the exception of a guy that I actually saw in real life, like in an actual court. In it was a court, uh, some jurisdiction, okay, as a public defender, as a it was during my public defender days. And I mean, I just went to court like I didn't have work, but I had to go to court because I had to watch him in action when I heard that he was pro se. But again, that guy actually did good. Again, he had one of my colleagues was standby counsel, so he direct him every once in a while. As far as cross examination, the judge would not, um, allow him to cross examine. I think the judge was wrong on that, though, because yeah, the judge was definitely wrong on that. This guy, again, he was charged with two counts. The one I believe was kidnapping, maybe three. It was kidnapping for sure, and there was another count which was something to do with an order of protection, that they alleged that he violated the order of protection. I think that was a misdemeanor. But anyways, the judge will not allow him to cross-examine. There was a witness on there. I actually did not like the witness very much. She was supposed to be, or at least not supposed to be, she was. This woman was the I think she was the property manager for the apartment complex. Because this guy, again, the victim in this case, the alleged victim in this case was his ex-girlfriend, a white woman, the man black. We're in the country, okay? We're in the country. But she had a clear bias, according to me. This witness had a clear bias against the defendant. But the judge would not allow the defendant to cross-examine as to bias, because I mean, it was partly his questioning. His questioning was, are you a racist or something along those lines? I don't actually remember. It was many years ago. But he was cross-examining as to bias, but he went head on. He pretty much attacked. He went straight in and went for uh, basically talking about racism and why people don't like that. So yeah, the judge definitely did not allow him to get into that. But overall, I thought that was this. This was actually a bench trial. Now that I think about it, it was not. Was a jury? I have to go back so many years. No, it was definitely a bench trial, which was a good move. Okay. Yeah, it was bench trial. On the felony, he was acquitted, but then he was convicted on the misdemeanor because, again, you have a court order telling you to stay away from this woman, and you guys are found together, or whatever. I guess exes that cannot leave each other behind. But other than that, he did really good. Okay. Brooklyn's funny. All right, Brooklyn. Thanks for sending that. I'll review it tomorrow. So I'll not be live tomorrow. I don't know if Benji's up here. Benji, if you need me to be live tomorrow, send me an email and I'll make it happen. Other than that, we will reconvene on Monday. We'll start off with Lori. And after we start off with Lori, the following day, the Tuesday, we're going to cover Karen Reed because I believe she has a hearing on that day, right? All right, folks, I'm calling it a night. I'm way behind. I'm just out here gossiping and talking about other people. But I'll see you guys on Monday. Have a good weekend.